Considering counterclaims in a debt law case, brought to you by Kenneth Chabert at yourlegallegup.com. Your advantage if you're being sued by debt collectors. I discuss counterclaims at great length in the litigation manual, and you should take a close look at that discussion. And at the Fair Debt Collection Practices Act, also known as the FDCPA, itself as you consider what, if any, counterclaims you will bring. For now, I want to tell you why counterclaims are so important and to give you a few examples of counterclaims you could consider. First, why is a counterclaim so important? In most jurisdictions, which is a fancy way of saying most courts and places, a plaintiff, that's the person bringing the lawsuit, is allowed to drop the case, which is called dismissing it, if it wants to, and usually at any time it wants to. This isn't true of federal court where you have to get permission, but in most state courts it seems to be true, and debt cases are pretty much always brought in state courts. And this translates into many and better legal actions against debt collectors. That means that at any time the debt collector could get tired of you and just dismiss the case. That's cool. But it could also sue you again later, or sell the debt to someone else who would sue you later. And that is definitely not cool. So how do you keep that from happening? By filing a counterclaim. A plaintiff can dismiss its own lawsuit, but not your claim against it. So a counterclaim gives you power over the plaintiff and lets you keep it around until the debt is actually destroyed, which we call extinguished. A counterclaim then means that you can put an end to the harassment. So what could be a counterclaim? Well, under state law, it could be anything they did that was wrong. You'll have to research anything the debt collector did that seemed wrong. Under the Fair Debt Collection Practices Act, though, I can give you a better idea. You can read the act in the handbook. Basically, it makes everything and anything the debt collector does that is unfair or deceptive, or could be deceptive to someone who didn't know better, illegal. So in the example I gave in the answer video, I told you that the debt collector did not say it was an assignee or assignee in its petition, but said instead that it had lent the defendant money. That was deceptive, since it was, 1, factually incorrect, and 2, suggested that the debt collector was actually the original creditor, which would have different legal rights, or had more information than it did, which was unfair and intimidating. It didn't matter whether the lawyers intended to deceive the defendant, although I certainly believe they did. It's just illegal for them to do that. They also claimed that after all the payments had been made, there remained a certain balance due, but the debt collector couldn't really know anything about the payments. We called that deceptive, although I have to admit that was a little bit of a reach. Remember also that they attached a cardholder agreement. This was simply a cardholder agreement, certainly not signed by the person they were suing. Do you see how calling it the cardholder agreement made it sound like the debt collector had an elaborate file on the defendant and documents, whereas in reality it had one blank cardholder agreement from the company which it claimed applied to hundreds of defendants. They had no records. And remember that defendants only see one of these cases at a time, so they don't know that they're using a blank agreement. But alleging that there was a cardholder agreement made lots of people think that the debt collector had the goods on them. That was deceptive and unfair and a violation of the FDCPA. See how that works? If they try to intimidate you into thinking they have any real records, which they essentially never have, they are breaking the FDCPA if they don't have them. And also think about how many people don't show up in court to contest these cases because they do think the debt collector has the goods on them. So this is a real violation. It matters. Also, it's a violation of the FDCPA if they try to get money from you that they have no right to. Remember the things I mentioned in the motions to dismiss video? If a debt collector sues you for an outdated debt or somebody else's debt, or to get money it isn't entitled to in any way, it is usually a violation of the FDCPA. Look closely at the law. And you'll make that your counterclaim. The next video will tell you how, in a nuts and bolts way, to file either a counterclaim or a lawsuit if you want to. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but I do know the legal process and debt law very well, so use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forms, and defend yourself from the debt collectors.